Please be seated. Shane, is that good?
We're on the record.
All right, good afternoon. Now, let's go ahead and set forth our appearances for the record.
Your Honor.
Good afternoon, Your Honor. Teddy Park on behalf of the plaintiff.
Good afternoon, Maggie. Good afternoon, Brianna Switzler for plaintiff.
Brad Johnson, Tyler Watson, Michael Esposito, and Eric Grimm on behalf of the defendant.
All right. I guess we're ready to continue. Is that correct, Mr. Kemp? Okay.
Do we want to address that now?
Just really quickly, Your Honor, we have
Oh,
a
I'm sorry.
stipulated exhibit list that's going to go back to the jury that defense has agreed to as well.
Okay, if everyone agrees, I agree.
We do.
All right.
That's your friend I met there, right?
Yeah, exactly.
Vernon, that's right.
Yes.
What's his last name again?
Running.
Retired?
Yep. So he's in Charles.
So what does he do?
How you doing? That's it, really? No, he got another job now. But he wants to get back to the West Coast. So I told him, why do you want to find the house?
He was working in D.C.
He was. Sit down to Hilton Head. And then now he's retired. He's in Charles. Yeah. No, he was actually in, they do, but he was in, Kentland. And then he was in New
All rise for the jury. Please be seated. Thank you.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
All right, ladies and gentlemen, I want to say good afternoon. And it's my understanding we're going to continue with closing arguments. Is that correct, Mr. Kemp?
Yes, Your Honor. Thank you, Your Honor.
All right.
Good afternoon, ladies and gentlemen. Let me explain briefly what we're going to do. This is what's called rebuttal. Okay, I'm not going to repeat all my opening statement again. I'm going to pick some of Mr. Johnson's points, and I'm going to try to rebut them. And then that's Mr. Parker's going to do the same thing Mr. Agan's going to do. So the first slide I want to show you is I kept track of what they spent their time on during the closing arguments. So Mr. Johnson went 5 minutes on Lisa King, 8 minutes on Bonnar, and then 42 minutes on all the others. You know, on the other 11, he spent from 11:20 to 11:52, then 12:10 to 12:20. And you have to ask yourself, I mean, it's pretty obvious. King and Bonnar were the big ticket items in this case. So why did he spend 5 minutes on King and 42 minutes on everybody else? Why did he spend 8 minutes on Bonnar and 42 minutes on everyone else? Well, I think it is because his underlying message, his main theme is, don't give these 11 people Blaine Jones money. Don't give them the $10 million that Blaine Jones testified to. That is his underlying theme here. All right? So what he is arguing to you is, don't accept the testimony on the case valuation that our very own vice president gave you. This was the testimony from Blaine Jones. And he says, oh, this testimony is somehow corrupt because, quote, this is what he said. Mr. Kemp said it, unquote. It's not an assessment of value, unquote. Let's focus on the facts, unquote. Well, Mr. Kemp didn't say anything, okay? Let's start with, Shane, can I have my first slide? This is the basic testimony. Question, you wouldn't go through this again if I gave you $10 million. Answer, no. Okay, look at the date of this, okay? It's hard to read, but the date is February 2023, 2 years ago. 2 years ago, Blaine Jones testified to this. All right, next, Shane. And this is the GoFundMe page. The hell and back we've heard about. Mr. Kemp didn't say this. This comes from a GoFundMe page that was created on October 25th, 2020. Mr. Kemp was not involved in the case at that time. And why do we know that? Because most of the plaintiffs were injured after that date. Okay? This is all Blaine Jones, held and back. So when he says Mr. Kemp said it, Mr. Kemp is making up this evidence, that is wrong. Okay, let's go to the $10 million valuation. Oh, excuse me, this is your jury instructions. This is jury instruction number 8. Statements, arguments, and opinions of counsel are not evidence in the case. Okay? That's why I did not give you this $10 million figure. I gave you the testimony of their vice president that an acute liver failure case was worth $10 million. That is not an opinion of counsel. That is not an argument. So what did Mr. Johnson do in response? He pulled these $500,000, $1 million figures out of thin air. Out of thin air, he pulled them. Didn't cite one piece of evidence for them. Not one single piece of evidence. So that is an argument of Mr. Johnson. That is not evidence in this case. And it gets worse. Can I have the next jury instruction sheet? The argument of counsel, Mr. Johnson's $500,000, his $1 million, is not evidence of reasonable compensation. That's not evidence, okay? The $10 million testimony from Blaine Jones, that's evidence. That's sworn testimony of the vice president. So what he is asking you to do is to violate your oath as a juror. You have to follow the instructions that the judge has given you. He's asking you to violate that. So if anyone back in the jury room suggests, oh, let's look at this 500,000 figure, let's look at this $1 million, the first question should be, is there any evidence for that? Because there's not. He didn't cite one single piece. He just created out of full air. So what he's arguing is, don't give anyone Blaine Jones money. Okay, so let's look at the Blaine Jones testimony. He says, well, Mr. Kemp made it up. Well, at the time of the deposition, there was no objection made. The real water attorneys were sitting right next to Blaine Jones, right next to Blaine Jones. Did they object when that question was asked? No objection whatsoever. There was no follow-up. You've seen during the case that the plaintiff goes first, they ask questions, then the defense gets to ask some follow-up. No one said to Blaine, well, you know, 10 million sounds like too much, maybe it should be 9, maybe it should be 8. No follow-up whatsoever. This was 2 years ago, okay? He had 30 days, he could change the deposition. He could change it for 30 days to the numbers Mr. Johnson is making up now. He could have said, oh, it should have been 500. Oh, it should have been 1 million. No change in 30 days. Okay, no change whatsoever. Was there any trial testimony? Did they bring Blaine Jones or anyone to trial? Blaine Jones come up here and say, oh, I was wrong, it shouldn't be 10 million, it should be 9, it should be 8. That didn't happen. This is the evidence in the case. And that is the evidence of the valuation of an acute liver failure case. Now, you know, maybe it's because my doctor, but my dad's a doctor, or was. but I always get frustrated when defense attorneys confuse medical evidence. And Mr. Johnson is confusing acute liver failure and acute liver injury. He tries to tell you that there's some plaintiffs don't have acute liver failure, they only have acute liver injury. Well, let's make this clear, except for Ms. Gossius and Ms. Strong, all of the other plaintiffs, and I'm excluding Bourdonnais and King from this one, all of the other plaintiffs have acute liver failure. Here's Dr. Hudson's testimony.
When you consider the medical records as a whole of these plaintiffs, Dr. Hudson, is it clear to you that hydrazine has caused their acute liver failures?
Yes, sir. Yes, sir.
Is it also clear to you that the consumption of hydrazine-laced real water has damaged their livers?
Yes, sir.
And he really seemed to focus on Abraham for some reason. Can I have his medical record? He told you that Abraham doesn't have acute liver failure. He says, Abraham doesn't have acute liver failure, he has acute liver injury. Here is the medical record. 2 different places. Liver failure, acute liver failure. Abraham has acute liver failure. Period. End of story. But to make it crystal clear, here's Dr. Hudson's testimony.
And all of the plaintiffs that you reviewed had acute liver injuries.
They did.
Okay, now let's flip to another subject. Magic liver theory. Okay, we're right back to the magic liver theory. He's trying to say, oh, if someone's injured by hydrazine, the liver repairs itself. That's the proposition that he's advancing to you. Okay? Magic liver theory. This is what his own expert said about the magic liver theory. There is no science that supports this. This is the science that suggests even if you get a small amount, you have permanent damage. Go ahead, Shane. And would I be correct that actually there is scientific literature that suggests that when people are exposed to hydrazine, even for one day or a small amount, not only does the liver not repair itself, but those people die. Would I be correct?
There are a couple case reports about this.
Yes. No magic liver theory when hydrazine is involved. And I put up their expert. I could have pulled quotes from Dr. Dadnow and Dr. Hudson, but this is their expert. This is their expert telling you that there's no such thing as a magic liver theory when you pour rocket fuel on the liver. Okay, next one, Shane. And I'm going to call this the magic liver theory, okay? You pour rocket fuel on someone's liver, magically the liver can regenerate itself. So when I'm talking about the magic liver theory, that's what I'm referring to. Okay, doctor, would I be correct that there is no scientific literature studying people that have consumed hydrazine that suggests that the liver can repair itself? None.
Yes.
No scientific literature. Scientific literature is evidence. So there's no evidence that supports this magic liver theory. Again, it's an argument by Mr. Johnson. It's an argument by counsel, which is not evidence. Now, I want to go to the individual plaintiffs. And I'd like to say that Mr. Johnson made mistakes. And I think I'm going to use that term, mistakes. Because he told you, and this is a direct quote, he told you, quote, no medical folks, unquote, have testified about Ms. Strong. Quote, there is no evidence of chronic injury for Ms. Strong, Mrs. Strong. Actually, there were 3 different doctors, one by an exhibit, who testified about Ms. Strong. We start out with the Summerlin Hospital, actually 4. This is Summerlin Hospital, right here. Moderate fatty infiltration of liver. Okay, you know, and he said the same thing with all these people. Everybody's normal, everybody's normal. He didn't talk about this fatty liver. It's right here in the hospital records. How can he say that Carolyn Strong is not permanently injured when the hospital record says it? But, next. Here's Dr. Dadnow, and he's our pathologist. And he's talking about the bridging. And this is Mrs. Strong's tissue slide. He's telling you there's bridging fibrosis. So I don't know why Mr. Johnson doesn't think that he's not a medical folk, you know? He's a doctor. He went to Harvard. He went to Harvard Medical School, the #1 medical school in the country. You know, their pathologist went to Penn State, which maybe that's a good football school, but it's not a good medical school. He went to Harvard, okay? And he told you that in STEM. Here's what he said.
Where's the bridging?
There's another one over there.
Where's the
You can see the
bridging?
fibrous tissue going zigzagging around from one to another.
Okay, and this is bridging fibrosis, it's not a regenerative nodule like Bonnar has.
Correct.
And just a little quick point, he stood up and said, "Oh, Dr. Dadnow, I impeached him." He didn't impeach him. If you impeach someone, you have to have their deposition. You have to have sworn testimony and show that it's inconsistent. He didn't even bother taking this guy's deposition. There is absolutely no impeachment. That was a complete fabrication, okay? But in any event, here's the testimony from Dr. Dadnow that there's bridging fibrosis. And I'm not done. I told you there was 3, okay? Here's Dr. Robin. This is their pathologist. Go ahead.
The biopsy report says portal inflammatory infiltrates, correct? Yes. And you agree with that? You saw that? Yes. And cholestasis, you saw that? Yes. Okay. And again, those 2 things that Porter and the 21-year-old, he had both those 2, right? Yes.
So here's their doctor saying that Carolyn Strong had the exact same permanent liver injuries that this 21-year-old airman who had 1-minute exposure to hydrazine and died had. Their doctor says this, okay? And he says, oh, there's no medical folks testifying on Miss Strong. That's just not accurate, ladies and gentlemen. That is a mistake. Okay, now turning to Miss Gassius. I've already told you, I've said this 3 times, Miss Gassius had moderate injuries, okay? We are asking you to award, take his $500,000. I'm fine with that, all right? But she has minor injuries, but she has severe psychological distress. She told you about the PTSD. She told you about the fact she's got to take care of the family because her mother's in the hospital for 3 or 4 months. But it's not a 0 claim, okay? It's a minor claim, I will admit that, but it's not a 0 claim. Okay, next plaintiff he talked about was Land Van Buren, okay? And again, he told you that she was fine, no permanent injury. Can I have the next one, Shane? I think we're on, I'm not going to interrupt you, Shane. Ginger Land Van Buren, opening statement, 33 to 34. I have Dr. Dadnow's testimony, or Dr. Hudson's testimony. If you don't have it handy, let's skip it and come back, okay? Okay, let's skip Van Buren and come back. I'm trying to show you some testimony about her fatty liver. Hopefully we'll get back to it. Let's go to Diaz. He says, Ms. Diaz has no injury. That's what he says, okay? Quote, no one has cirrhosis, unquote. That is exactly what Mr. Johnson told you. Okay, let's see what Dr. Dadnow said. Go ahead. Oh, no. This is Dr. Robin. Go ahead, you want to play that?
Okay, so ALT 123, 145, 134, 115, and then 34, it almost goes back to normal on day 21. So he has elevated ALTs, right? Yes. Ms. Diaz she had elevated ALTs of 2,000, right? Yes. And let's take a look at this poor airman's ASTs. 321, 378, 204, 152, and 19. correct?
Yes.
All above normal.
Yes.
But Ms. Diaz had ASTs in the thousands, correct?
Yes.
So, would you agree with me that Ms. Diaz had a more serious injury than Ms. Airman?
It appears that way, yes. She had more severe acute injury. Yes.
Okay, fair. And the same is true of Carolyn Strong. She had higher ALTs and ASTs than this too, right?
Yes.
So this is the defense pathologist telling you that both Diaz and Strong had more severe injuries than the 21-year-old airman, 1 minute of exposure, who died. This is the defense admitting this, all right? And then he comes up and says, oh, Ms. Diaz is fine. Give her, I can't remember if she's a 500,000 or a million. In addition to that, we have Dr. Datnow's testimony. Go ahead, Shane.
Okay, did you find periportal and pericellular fibrosis here?
Yes, you can see here's a liver cell and it's surrounded by blue fibrous tissue that's pericellular. This is the portal area, so that's periportal.
Okay. And you graded this what?
1 to 2.
Okay, we're back to Strong again. This is our pathologist saying Strong has pericellular fibrosis, periportal fibrosis. And again, this is the plaintiff that Mr. Johnson told you that there were no medical folks talking to about no evidence of chronic injury. Well, no evidence of chronic injury other than periportal fibrosis that we see on the tissue slide. Next one, Shane.
All right. In addition to regenerative nodules, does Vanya have bridging fibrosis?
Yes.
And when you have regenerative nodules and bridging fibrosis, is that a permanent injury to the liver?
The regenerative nodule is a permanent change.
Permanent injury, cirrhosis, regenerative nodules, and remember there's 50,000 of them, regenerative nodules and bridging fibrosis. So not only does Vanya Diaz have an injury, it is cirrhosis, okay? And to make this crystal clear, next one, Shane.
So cirrhosis, doesn't get better, not repaired by the liver over time. Is that your opinion to a reasonable degree of medical?
Yes, once cirrhosis is occurred, it's irreversible.
Permanent injury. You know, and he claims Dr. Datnow flip-flopped from his deposition. He didn't take his deposition. That is a complete falsehood. He did not flip-flop on his deposition because there was no deposition taken. Okay? Made that up. Right? Next one, Shane.
If the slides show bridging fibrosis for Diaz and regenerative nodules for Diaz, she has cirrhosis, correct?
Well, not necessarily, but yes. Individuals who have bridging fibrosis and regenerative nodules have cirrhosis, but there are early stages where you might see regenerative nodules and what we would call bridging fibrosis.
And cirrhosis is the highest stage of liver scarring, correct?
Yes.
So Mr. Johnson stands up here with a straight face and he tells you, quote, no one has cirrhosis, unquote, when his own expert tells you that Vanya Diaz has cirrhosis. His own expert. Okay, next one, Shane.
If the slides, okay, if by that you mean there's some sort of way to lessen the impact, you can't cure the cirrhosis, right?
No.
Right, it's there, the permanent scarring is there.
Yes.
Forever.
Yes.
Permanent, forever, can't be cured. That is their expert. That is his expert, okay? Let's go to Chang's Lane. Shane, as much as I work with Shane, I change his name, it's pretty bad. So, Mr. Johnson tells you that there's no injury. This plaintiff has no injury, she's normal, everything's fine. This is what the hospital says. There is severe fatty infiltration of the liver. Fatty liver. This is a permanent injury.
I have a testimony on that, Jeremy, if you want.
Okay, let's do, you've got Hudson ready for Chang, and then we'll go back to Van Buren.
The 12? 12 means you've got a ton of cellular damage, like widespread cellular damage, and that's because the liver was so damaged, it was not able to clear the lactic acid that is produced normally by ourselves, because the liver clears the lactic acid. That's our main way of getting rid of lactic acid.
And is that an indication to you, in addition to everything else that you discussed, proof positive of liver damage caused by hydrazine?
Yes, sir.
So Nicole had a lot of things going on, Nicole Chang. High lactic acid to 12, the ammonia, and in addition to that, the fatty liver. And there's the testimony that the doctor indicating that's a permanent injury. All right, let's go back to Van Buren so I don't forget. He told you Van Buren's fine, normal, no problem.
This is Van Buren, Land Van Buren, I should say. Now, her medical records also indicate that she suffered fatty liver, is that correct?
That is correct.
Fatty liver, no doubt about it. You remember Van Buren's the one that had the 27 INR, the blood squirted out, got all over her jeans, highest INR anyone's ever seen. And he says, she's fine. Okay, next one we go to is Nigel. Again, fatty liver. Play it, Shane.
Did he suffer, in your opinion, a permanent injury based upon his consumption of real water?
Yes, sir.
Okay, let's go to JJ.
Did he suffer?
Here's the radiology report, the x-ray they did on him. Extensive fatty infiltration of the liver. Fatty liver, permanent liver injury. Okay? It's in the medical records. Next one, I think we have Dr. Hudson confirming this.
Mrs. Delmar, from your review of his medical records, did he too suffer fatty liver as a result of his consumption of real water?
He did.
And is it your opinion that based upon that he has suffered a permanent liver injury?
Okay, let's go to the next one. I know I'm being quick, but I'm trying to be quick. Carrie? Yeah, Mr. Johnson, this guy's fine. He's fine, he's fine. So here's what the hospital record found. Likely fatty liver again. No dispute about this. And I think we also have some testimony from Dr. Hudson on this.
Based upon your review of his records, did he too suffer fatty liver as a result of consuming real water?
He did.
Okay, let's go to the next plaintiff that's supposedly fine, Mr. Morris.
So, Mr. Morris, did you review his medical records as well?
I did.
And based upon your review of his medical records, did you find that there was fatty liver, that he suffered fatty liver as well?
Yes, sir.
And based upon your review of his medical records, did he suffer a permanent injury?
Yes, sir.
Okay, fatty liver, permanent injury. He's not fine. And I'm trying to go fast, ladies and gentlemen. I'm trying to get you out of here. You know, so I'm sorry. I know I'm speeding, but there's a reason for it. Okay, and Nally's the next one. Let's see the hospital slide. Again, fatty liver. Gee, I think I'm sensing a pattern here. You know, this is the hospital slide. Mr. Johnson says, "Oh, there's no permanent injury here." Here's what the hospital says. Can I have Dr. Datnow, please, or Hudson?
And is it your opinion, Dr. Hudson, that Ms. Nally has now suffered a form of permanent liver injury based on her consumption of real water?
Yes, sir.
Okay, and one more with Abraham before I go. Would I have one more on Abraham? Did I already do that one? I think I did that one. Okay, let's go to the jury instruction. This is my last point, ladies and gentlemen, and I've made this point already. It's jury instruction 24. Oh, you have Abraham? Okay, go ahead.
Did Abraham also suffer, based upon his medical records, a fatty liver because of his consumption of real water?
Yes, sir.
And do you also believe that Mr. Oliveira has suffered a permanent liver injury because of his consumption of real water?
I do.
So for the next 60 years, Abraham has this permanent injury, fatty liver. And Mr. Johnson says, oh, give him the $500,000 I made up. That's not the law, ladies and gentlemen. This is the law. Jury instruction 24. Let's go to it one more time because I want to emphasize this point. Shane? The argument of counsel is not evidence of reasonable compensation. This 500,000 million that he just made up out of thin air, that's not evidence, okay? The only evidence you have for these acute liver failure cases, remember there's 9 of them. 9 of the plaintiffs are acute liver failure, just like Blaine Jones, only worse because they have permanent fatty liver, he doesn't. The only evidence you have is Blaine Jones' $10 million testimony. That's it, that's all you have. And I would urge you to follow the evidence because that's what the jury instructions commands you to do. Thank you very much, ladies and gentlemen. I'm sorry I was fast.
Okay, thank you, sir. All right. Okay, Mr. Parker.
Yep. Thank you, John.
Yes, you may.
Thank you so much. Good afternoon, everyone. Everybody good? Good. All right. So let me address a few of the things that Mr. Johnson said in his closing, and then I'll get to what I intended to say as a part of my rebuttal. Okay? So it may seem a little disjointed in the beginning, just because I want to make sure I address what he said, and then I'll go on a little further. So I'm not sure whether or not Mr. Johnson has a clear understanding of the medicine, because he's made some statements today, again, argument, that appears to indicate that he does not understand the medicine. One thing that we can all agree, including Mr. Johnson, is he didn't put in front of you a single medical journal, article, anything on the science. Nothing. Zip, zero, nada. And it's because the science doesn't support anything he said. I mean, it's so easy. If you sit down, you're sitting down, fortunately, and you consider what he has said and argued. Mr. Johnson would have you believe that all of these plaintiffs have suffered no permanent injury. Now, how could he know that, ladies and gentlemen? Let's think about that. How could he know? The only way he would be able to know, or any doctor, is through a biopsy, correct? There's only 3 people that have had biopsies, and they had those biopsies early on in their treatment. So all the doctors agree, including Mr. Johnson's doctor, Dr. Alcina, that he cannot tell or rule out that they have permanent injuries because he doesn't have up-to-date biopsies. So Mr. Johnson, and I give him credit for the kind of novel approach at not using the science but throwing out, bits and pieces of a deposition. And you remember when I caught him on the issue of the deposition from Dr. Hudson, he asked the question, gave you a part of the deposition, and then I asked Dr. Hudson to look beyond that, and it was 2 pages of explaining the answer. Well, this is the answer. All of the science tells you, and I showed it to you, and that's all there is, that people who congest or inhale hydrazine suffer permanent injuries. That's it. And the reason why he didn't put a single article, peer-reviewed medical article up there is because he knows it does not support his position. And those articles that were written, they weren't written by our doctors. Those doctors had no skin in this game. And that's what they said. The machinists who died, the physicians that prepared that report, they weren't our doctors. They didn't come and say, hey, we're going to write these reports in 1971 to help your case out, or in 2018 to help your case out. That was just the truth from unbiased professionals trying to figure out what has hydrazine done to these two people. The 59-year machinist who just touched or exposed to hydrazine once a week for 6 months, I'm sorry, and the young F-16 crew member who inhaled it for less than a minute. That's the science on what hydrazine does to the human liver. And the reason why Mr. Johnson chose not to put that on that screen, despite being in front of you for 1 hour and 58 minutes on closing, is because it does not suit his purposes. And that's it. That's the medicine. So I wanted to make sure you were clear on that. One other thing he said, and this surprised me. Mr. Johnson said that, this was early on in his closing, he said there's no good guys or bad guys. Remember that? I don't know if you remember, real early. And he said, my client is not a monster. Well, how would we know that? Have you seen his client show up a single day in this trial? Have we seen any real water owners, representatives sitting in that gallery?
Can we approach?
Morton, yes, please. So, Your Honor, is the objection overruled?
Overruled, thank you, sir.
Thank you so much. So as I was saying, we don't know what his client looks like. Be it a monster or not a monster. But we do know that they didn't show up since you've been here. Whereas...
Objection, Your Honor, they did show up, they were deposed.
Oh yeah, I forgot. They were on the screen, depositions. As opposed to the clients that we have here that have been here for virtually every day. Now, unfortunately, Ms. Bordenave, and I told you what was going on with her father. He was placed in hospice yesterday, last night, actually the night before. And so,
Can I approach?
Do we have an objection?
yeah, do we?
Yeah. I thought you didn't want me to object from here, Your Honor.
Oh, come on.
It was overruled.
Judge was granted in part, denied in part. How's that?
Yeah, we'll take that. So, unlike real water, Ms. Bordenave is not here because her father remains in the hospital. One other thing, well, not one, I got a few others. So Ms. Bordenave had a biopsy. You guys remember that while she was in Centennial Hills, March 3rd. The biopsy indicated that she needed to be seen by a hepatologist, ultimately resulting in her going to where? Keck by way of air flight. Understood. She was found to have autoimmune hepatitis. In addition, approximately a year later, she goes to an ultrasound, elastography, finds out that she has severe fatty liver. A year later, actually 2 years later, a year later, July 21st, 2020, she goes in for another liver check. Now she has, in addition to fatty liver, she has an enlarged liver. Her liver is becoming worse and worse. Her injury is progressing more and more. For some reason, Mr. Johnson puts up on the screen that she's doing great, which I was surprised, I have to be honest. I was truly surprised that Mr. Johnson kept up with that great approach.
Objection and proper argument, Your Honor.
You said yourself you found it funny and doubled down. Really?
What's
Mr.
the
Johnson?
objection? Wait. What's the objection?
Objection is a proper jury argument when you address this in a motion to eliminate.
Motion to eliminate.
What's it? I don't know. That's not an emotion. Anyway, let's move on. I'll overrule.
Thank you, Your Honor. And so obviously she's not getting better. she's getting worse. And that's the situation. She's been on and was on medication for AIH for 3 years. Based on the science, in the next roughly 18 months, she'll have a relapse. That's not based on Dr. Hudson's testimony, and he repeated it, but his research is based on the science. Dr. Datnow didn't even reference the science, and that's why he's not using it in his closing. Both Dr. Hudson and Dr. Alsina agree with the science. And so I would suggest to you the reason why he didn't use a lot of testimony from Dr. Alsina is because Dr. Alsina agreed with most of what Dr. Hudson said. In fact, he said he could not tell if these plaintiffs had permanent injury because there had been no recent biopsies. But he did say, based upon the science, the consumption of hydrazine leads to permanent injuries. That's what he said. And one thing that all the doctors agree, Hudson, Alsina, and their doctor, Dr. Robin, they all agree that when it comes to permanent injuries, the way you tell is with a biopsy. But medically and ethically, they cannot do biopsies on these plaintiffs at this point. So as a result, they can't tell you that they did not suffer permanent injuries. And that's just the science. You don't have to rely on me. When you go back to deliberate, you'll get to look at the science yourself. And you'll see exactly what I put on the screen. Shane, can we have you play the first clip, please? And so once it's been triggered, once that drug, or in this case a chemical, has triggered the autoimmune hepatitis, will patients have that the rest of their lives?
Yes. Yes. The autoimmune hepatitis continues. But you treat it like you would what I call sort of the ordinary autoimmune hepatitis. And as long as those patients are treated, they will do well. But people sometimes, lots of times, tend to want to go off their medication. The relapse rate is 40 to 80%. 40 to 80%. So these people have a lifelong condition. It may go into remission for a while. That's why I say the relapse rate is 40 to 80%. And really on the higher end, or closer to 80% in my experience in the years that I've been doing this. So these people require monitoring and treatment for the rest of their lives. They're not cured. Just because they go in remission, they are not cured. They are not done. Very, very high chance they're going to recur.
So when Mr. Johnson got up and said to you guys, Ms. Bourdonnais is in great shape, Ms. King is in great shape, you know, the best seems to be happening for them. That's not the science. It's just not. And there's no medical doctor that can say otherwise. Dr. Alsina agrees, Dr. Hudson, as you heard. In fact, let's hear Dr. Alsina's comment on the subject.
This is no video.
I'm sorry. I wanted to show you this just because I want you to see what Dr. Alsina thinks of Dr. Hudson. And so you would agree that Dr. Hudson is unequivocally qualified to provide expert opinions. Yes, I agree. That's Dr. Alsina's comments about Dr. Hudson, as opposed to the arguments you heard from Mr. Johnson. Mr. Johnson decided his approach was to attack Dr. Hudson. But another hepatologist, Dr. Alsina, retained by Real Water, this is his opinion of Dr. Hudson. Next slide.
And as a result, no expert can say that those were not permanent injuries in terms of the death of those liver cells from consuming Real Water with hydrazine, correct?
Correct. So I put that up there because Mr. Johnson in his closing talked about, again, the permanency of those injuries. Dr. Alsina says, so you don't have to take it from me. Take it from Real Water's expert. Real Water's expert said, hydrazine kills liver cells. Plain and simple. That's everyone, we can all agree to it. And there's no proof whatsoever that those liver cells have regenerated. None. Next slide, Shane. Before we get there, again, Mr. Johnson doubled down on whether or not the plaintiffs have presented treating doctors as opposed to expert doctors. Keep in mind, Mr. Johnson has not presented a single expert here who's not a retained expert. His experts didn't ask for an IME. They could have done an independent medical examination of each one of those plaintiffs if they wanted to. They chose not to. If they had some discrepancy with their own treating physicians' determinations, medical determinations, Mr. Johnson could have asked each one of them, pursuant to our rules. And just to throw a Keanu Reeves line in this, if we don't live by the rules, then we live with the animals. The point is, he chose not to have an expert, medical expert, hepatologist, gastroenterologist do an independent medical examination on each one of them. That was his decision, because all of the treating physicians, all the medical records we've put on the screen have come from their treating physicians. His experts, Dr. Robin, paid expert, didn't do an IME. Dr. Lynn, paid expert, didn't do an IME. That's what he brought to you. And then chastises the plaintiffs for using their own treating physicians' medical records and having Dr. Hudson or the toxicologist review them or the pathologist review them and give you their opinions based on the science. Next slide, Shane. So this is Mr. Johnson. I thought I'd show you a skit of Mr. Johnson during my rebuttal closing. Go ahead and play it, Shane.
If a person, he will testify that if a person suffers from a hydrazine-induced liver injury, they have a 100% chance of relapse once they stop taking the hydrazine. That's 0%. I must have misread that. A 0% chance of relapse on a liver injury once you stop taking, that's right, a toxic hydrazine. Once you do that, you have a liver injury, you have 100% of no relapse.
So that's his testimony. Next slide, Shane. Now I want you to listen to Dr. Robin. I believe he's next, correct, Shane?
I'll see you there.
Go ahead. Now, that's right. Thank you. Go right ahead.
Defense experts. Go ahead. Call Dr. Howard Robin. He is a pathologist. He's a consultant to laboratories, clinical research organizations, and pharmaceutical manufacturers. He was trained at Chestnut Hill Hospital, Thomas Jefferson Hospital, and Scripps Clinic and Research Foundation, and has clinical and pathological expertise in kidney and liver disease. He'll testify on behalf of the defendants.
That's Dr. Robin, the doctor that Mr. Johnson and Real Water hang their hat on. Let's see what Dr. Alcina, Real Water's other expert, thinks of Dr. Robin. Go ahead.
Let's see if we can start with some easy questions, Dr. Alcina. Both you and Dr. Hudson are board-certified hepatologists. Is that correct?
He's a hepatologist. I'm a board-certified surgeon, general surgeon.
Okay. And you do liver transplants, correct?
Yeah, I've done that my whole career. Yes, sir.
Okay. And you know that Dr. Hudson has been the head of liver transplant departments, correct?
I am aware of that.
And as Mr. Eglett discussed with you, he's been the head of several hepatology departments as well as gastroenterology departments, correct?
He has been.
All right. Is it your understanding that the defendant's expert, Dr. Robin, is neither a board-certified hepatologist nor board-certified gastroenterologist?
I'm aware of that, yes.
Is it fair to say that he is a pathologist?
He's a pathologist.
Is it also fair to say that pathologists typically do not treat patients directly for hepatology or gastroenterology issues?
They do not.
That would be reserved for hepatologists and gastroenterologists, correct?
Yes, I mean clinicians.
That's right. And he's neither, correct?
He's a pathologist.
Not a clinician, not a hepatologist, not a gastroenterologist, correct?
Correct.
And in fact, in terms of treating patients with hepatology issues, that would be the hepatologist, both leading up to a diagnosis as well as a prognosis, correct?
Yes.
And as well as following treatment after a diagnosis has been made, correct?
Correct.
Be it through a liver transplant or just continuing care, correct?
Yes, that's not a purview of pathology.
Thank you. And so Dr. Robin would not be the person treating patients for hepatology issues or gastroenterology issues, be it before prognosis or even after before diagnosis as well as after diagnosis, correct?
I agree with that.
All right. And in terms of future care, that's also reserved to clinicians, be it hepatology or gastroenterology, correct?
Yeah, or the other liver specialties or whatever specialty that involve transplantation or chronic diseases or whatever.
Right. But none of those would be the pathologist, correct?
Correct.
So, Mr. Johnson brings you a pathologist to give opinions on hepatology and gastroenterology. That's what he chose to do. And even Dr. Alcina, Real Water's hepatologist, says that's not what a pathologist does. He does not treat people with hepatology issues, liver issues, or gastroenterology issues, GI issues. He doesn't do it. He simply does not do it. He's out of his ballpark. He's out of his wheelhouse. He stretched out and overreached and gave you opinions he's not qualified to give because he's not a hepatologist and he's not a gastroenterologist. And again, you're not taking my word on it. You're not taking Mr. Kemp's word on it or Mr. Egler's word on it. You're taking Real Water's expert on it. Evidence. Next slide, Shane.
Okay, and based upon these articles, you would agree that as time goes on, there is a greater likelihood that both Ms. Bordenave and Ms. King will suffer relapse of autoimmune hepatitis, correct?
Yeah, according to that reference, yeah.
So I played that just so there'd be no denying it at the end of the day. When Mr. Johnson said 0% chance, that's not what his expert said. His expert does not agree with Mr. Johnson's comments. Your Honor, can we approach?
Yes. Yeah, whatever it is. If you want to break, Mr. Parker, go ahead. Want a break? It's up to you.
I think people want to roll and keep going.
Keep going.
I saw a bunch of, keep moving.
Does everybody want to continue on, right? Yes. Mr. Parker, you have the floor.
I'm gonna have to take a break between, Your Honor.
Oh, I understand. As soon as it, yeah, you can, Mr. Eglett. I have no problem there. Mr. Parker, sir.
May I continue on?
Yes, you may.
Thank you.
My bad.
All right, next slide, Shane. So as you know, Ms. Bordenave got her undergrad degree from Family and Consumer Science, and then she did a year master's in education. And it's because she wanted to be, and ultimately became a teacher of special needs, children with autism.
Next slide, Shane. She worked in LA County, where she again worked with special needs children. She became a substitute teacher here at Clark County, then a paraprofessional in Clark County as well. I raise that so that you can consider both past and future. That Ms. Bourdonnais dedicated roughly 11 years of her life to teaching special needs children. On top of that, 5 years of education. That was her passion. So when you consider a verdict for her, both past and future, know that real water took that away from her. Her doctor said it's not safe for her, given her compromised immune system, to be around children. So now, the rest of her 34.1 years, she's going to be doing something that she does not have a passion for. What I thought was somewhat, I questioned the motive of Mr. Johnson when he raised the fact that she works from 7:30 to 4:30 every day, a full job. She did that because she's a hard worker. But that it's not a substitute for doing what you love to do. We all know here that a work year, 2,080 hours. 2,080 hours. The year, 365 days, excluding leap years, is roughly 8,500 hours a year. 1/4 of your life is spent at that office. 1/4 of your life. So 1/4 of her life will be spent doing something that she does not have a passion for. She's working to support her family. She's not working in the field that she has a passion for. So when you consider her past and future damages, please consider that real water cost her the career she had a passion for. Next slide, Shane. So these are the numbers I put on the board, and I want you to see this because the verdict form does not have a separate place for future pain and suffering from future meds, so I combined them. Let's go to the next screen so they can see the verdict form. And so when it comes to past, we're suggesting for Ms. Bourdonnais the $15 million number. And when it comes to future, this is the number, this is the total. 34.1 years of her life, the loss of the career that she had a passion for, along with what the experts seem to all agree that she will have to look forward to for a lifelong of autoimmune hepatitis. Mr. Johnson and I have agreed that she will need psychological or psychiatric help in the future. So we've agreed that she will have that medical care provided to her. So that's why you won't see that for Ms. Bourdonnais. Okay? And we're not asking for it. Nor are we asking for Ms. Bourdonnais to receive some lost wage claim. We're not asking for that because she's working. It's just that you consider what she's lost because of consuming real water. Next slide, Shane. Now we switch to punitive damages. Next slide, Shane. This is the jury. This is how we see it. That's how much evidence we believe there is supporting punitive damages. Certainly clear and convincing, the evidence has been in this case. Next slide, Shane. So jury instruction number 30 says, and again, this is the standard. The burden of proof here is clear and convincing evidence. We believe there's a ton of evidence. Go to the next slide, Shane. That supports that real water is knowledgeable of the probable harm to its customers and to the public, acted willfully and deliberately to avoid those consequences. Next slide, Shane. And this is generally the evidence you've heard. After receiving dozens of complaints, Real Water did not perform any non-targeted GCMS testing Go right ahead, Shane. Put them all up. Even after Mr. Blaine Jones became ill, and the VP of production begged and pleaded for him to recall, he refused to do it. After receiving dozens of termination notices based upon medical causes, they failed to stop production or do a recall. And after the FDC, CDC, and Southern Nevada Health District began its investigation, Rio Water refused to cooperate. Next slide, Shane. And these are the people that Mr. Johnson chose to present to you, or we chose to present to you, from Rio Water. These are all Rio Water employees. Michael Bush indicated that out of from 1 to 10, play his slide. Oh, I'm sorry, maybe this is quicker anyway. He said from 1 to 10, there was a 3 or a 4. That's what his testimony was. Next slide, Jane. Ms. Converse, the receptionist turned Director of Quality Control. Shane? No testing, no testing, no investigations, just give free water. Complaints from Florida to Oregon. Next. This was her testimony. I'm not going to play it because I think you probably remember what she said. She said that on Monday mornings, this is what I took away from it, that the only issue had nothing to do with investigations. It's about how many trucks got out with real water product. Next slide, Shane. Next slide. Mr. Desitel, the production, fake director of quality control, he testified that out of a 1 to 10, it's a 0. Play it, Shane.
Did you approve of the way the real water operation was run?
No, I did not.
In why?
Haphazard, no control, no leadership, just in disarray. That's why I only stayed 8 months.
Okay, and on a scale of 1 to 10, you have to rate good and bad operations. How would you rate that?
0.
A 0. So one said 3 or 4 out of 10. One said 0 out of 10. Patty Converse said what their interests were. Mr. Mendigana, they brought him forward by video, and he had nothing to do with quality control. It had nothing to do with the making of real water. He offered no opinions as to quality control. He was not aware of what was happening in the concentrate room. So when Mr. Johnson talks about he wanted to discuss the issues at hand, well, the issues in terms of punitive damages is what efforts they made to make this water safe. This person certainly didn't testify to that. Next slide, Shane. We're not going to play it because they remember what Mr. Randolph said. They said he said no matter how many times he begged Blaine to do a recall after he explained that his nephew got sick, his brother-in-law's friend got sick, that he refused to do a recall. Next. No, they remember him. We know what Dr. Hutt said about their lack of an investigation, their lack of training. Certainly, the FDA found similar findings. Next slide, Shane. Now, these are things you may not remember. And some of these actually new. Next slide, Shane. This is the establishment inspection report. Henderson, Nevada, March 16th. This is the FDA CDC investigation. Next slide, Shane. I showed you a few of these during the opening. But I want you to know and understand just how much Blaine did to avoid cooperating with the CDC, the FDA, and the Southern Nevada Health District. First day, records were requested on the first day of inspection, 3/16/21, and not immediately provided. By the second day of the inspection, the Vice President said all records requests would have to go through his attorney. Does that sound like someone who's trying to cooperate with the authorities to figure out what's going on with all these people that are getting sick? Next slide, Shane. We know that they found that the product was adulterated, and we know, although we didn't spend a lot of time on it, there were 483 observations that were found to be in violation. Go right ahead, Shane. The manager, Anthony Brown, received 25 to 30 complaints of odd-tasting water. Brown stated 7 to 8 of these complaining customers were reported vomiting. Mr. Brown provided copies of 5-gallon delivery account terminations from Nevada, California, and Arizona, 7 account terminations in 2019, another 7 in the beginning of 2020, and then 23 at the end of 2020. Complaints of off taste and nausea. Now, I want you to keep this in mind because Blaine knows this. The company knows this. You would think that the president, Brent Jones, knows this. Next slide. So now we move from Henderson to Mesa, Arizona. That inspection started 6 days later. Mr. Brown does not provide training on food hygiene or food safety and does not maintain records of training. Next slide, Shane. These are the bacteriological tests that Mr. Johnson said they did all the time. This is what they informed the FDA. And we were not provided documents showing samples and testing was done. Mr. Brown said that to the FDA investigators. It says the firm was also responsible for taking and analyzing bottled drinking water for bacteriological testing, specifically coliforms, which we know they found that in their water, at least once a week in chemical, physical, and radiological tests, at least annually, and they didn't provide it. Next. This deals with the hiding of the secret room, and I alluded to that earlier. The second section is where the mixing of the concentrate takes place. During the initial walkthrough, Blaine Jones told us the processing area consisted only of the main bottling area. This is just an untruth, a misrepresentation. He did not tell us that the adjacent section was part of the production, and this section was not included in the diagram provided to the Southern Nevada Health District. So not only is he telling an untruth to the CDC and the FDA, but when he did the information required by the Health District, he wasn't truthful with the Health District. In the company's permit application, although it is included in the lease. So he had a lease that showed it, didn't provide that to the Health District, and never informed them. Next. So this question was asked of Dr. Naja, regarding how you're supposed to work with the authorities. Go ahead.
Is it fair to say you're concerned about the public health? You don't hide the process from the FDA, the CDC, and the Southern Nevada Health District?
That's a reasonable statement, yes.
Next slide, Shane. Blaine Jones refused to answer questions about the bottled water production, and he stated all records requests would have to go through his attorney. Continue. We scheduled a noon appointment with Blaine Jones to accommodate his personal schedule. So they're doing their best to work with this guy. Mr. Jones, we informed Mr. Jones that we were at the facility for the pre-scheduled meeting and requesting a return call. No return call was received. He didn't even show up. That's how concerned he was about the public's health, given what was going on. Shane. Mr. Jones refused to provide requested processing records. He said they were lost in the move from Las Vegas to Henderson. That's his excuse for not providing records. Mr. Jones said he would not answer any of our questions, but did show us a section of the building where the real water concentrate is mixed. Finally agreed to do so. Go right ahead, Shane. Again, refused to provide any requested documents to the inspection team, offering 2 new excuses. This time, the excuse is the firm's chemical supplier would not be able to provide any documents until Monday, and the firm's legal counsel still needs to review all the requested documents. The papers got lost in the move. Now he's got to check with his chemical supplier, got to check with his lawyer. Everything except cooperation. Next. Finally, he informed the CDC and the FDA and the Southern Nevada Health District that he didn't want to inform them of the ionizing process because he didn't want to tell them in front of his own production manager. Hey, how many excuses can you have? Shane. Go right ahead. This is September 21. And these are the consequences. You have pets dying, 1 dog, 3 dogs, 1 cat, 20 probable cases reported, 23 hospitalizations and 1 death. That's the consequence of their refusal to work with the CDC, refusal to do a production stop, refusal to do a recall. Shane. And I'm not going to go through all of these claims again, but certainly you remember we have claims of people going in the hospital in 2017. We have claims of people going to the hospital in 2020. This person unfortunately had product issues 2017 and 2018. Next, Jane. And this unfortunate person asked, and this only makes sense. He informs them that he also got sick and asked, this is in November, why are they still selling this stuff? And the reason why is because Real Water is more interested in money than public safety or the safety of their own customers. Go right ahead, Shane. Play that.
Are you familiar with this document?
No, I'm not.
How about page 20 of this document? Have you seen a list of these toxins or poisons identified by the CDC? You've heard of the CDC, correct?
I have.
You see where hydrazine is identified on this list of toxins?
Yep, I see it.
Is it fair to say that the tests that you performed or that were performed on Real Water did not include testing hydrazine?
It's my understanding that those tests didn't include testing hydrazine.
Did or did not?
Did not.
Thank you, Barry. One other question. Is it fair to say that hydrazine was found in the Real Water concentrators?
I was made aware of it after a certain time. I was asked to actually go through my depositions. I found out that it was found in product.
And so from roughly 2008, when you began working there, until 2020, Real Water never tested for hydrazine, correct?
Not to my knowledge.
So you know the history now. 2013, all the way through the time 5 children were sent to Salt Lake City. We have complaints. Across the country, terminations, a ton of information that Real Water received and chose to do nothing. Now I want you to listen again to what Mr. Brent Jones said.
Okay, Mr. Jones, back on the record, I wanted to take you back to the time period around the recall, March of 2021. And I think earlier, you're in Panama, is that right? Correct. And I think you said you were blindsided by this news.
At this time, I don't know if I knew at that point. Obviously, hindsight now as it's developed. We didn't know, I remember at the beginning, didn't know what the issue was whatsoever. The FDA came into the Las Vegas facility initially, and they didn't really roll out a mace, I think, for a week or 2. So it was focused on the home office delivery because we did not sell any ready-to-drink out of that facility. It was all sold by distributors such as UNFI or KE or Nevada Beverage. So at the point that this happened, it was believed it was only associated with the home office delivery. And I guess subsequently people claim that they're ready to drink, but at the time we didn't have any thoughts that it was any association.
Well, did you do any investigation into what went wrong when people got, first of all, let me do this. Are you aware of an association between consuming real water 5-gallon jugs in the fall of 2020 and liver injuries?
I'll just, so we can cut the chase, I'll answer, I think, what you're asking me. And if it isn't, you can get me to clarify. We had no idea that I had no idea that our water was causing problems. My own son Blaine got very sick, and at the same time, we didn't stop drinking raw water. We didn't have any idea that it was associated with raw water whatsoever. I mean, he got sick himself, and if we would have thought it was raw water, we would have done something. At that time, we didn't, because we didn't know there was any association whatsoever with real water. So no, I did not think that there was any problem with real water in October or November of 2020. I was completely blindsided when it happened in March. No.
Okay. Are you aware that hydrazine can be used as a type of rocket fuel?
I'm not aware of the use for hydrazine.
All right. Would you agree with me that hydrazine or potential rocket fuel should not be in a real water product?
Yes, I would agree that it should not be in a real water product.
Now let's figure out who's telling the truth. Blaine said to the FDA, the CDC, and Southern Nevada Health District that they knew about the terminations, they knew about 25 to 30 customer complaints based upon illnesses. They were aware of the pet issues because of letters. You heard Ms. Doran, Mr. Fisher, all of those. Repeated it to the CDC and the FDA. Now how can Mr. Brent Jones, the president of this company, say he had no awareness of this? None. Under oath, that's what he said. In November of 2020, when you got complaints from 2013 all the way through, who's telling the truth? So it's one or two things. Either Brett Jones is not telling the truth, Blaine Jones is not telling the truth, or they're both not telling the truth. There's no way of reconciling it. There's just no way. You can't say you're aware of all of these complaints and then Mr. Brent Jones gets up and says, I was not aware of it. He's the president of the company. And then he says he didn't do an investigation. Something Mr. Johnson said during his opening that they did. No investigation, and Blaine says no testing. What type of message would you be sending if you did not determine that punitives are necessary? Would you be condoning this kind of conduct? Would you be encouraging this kind of conduct? You get that many terminations for medical reasons, you get that many complaints, people vomiting, going to the hospital, you don't respond to the complaints, and then you get up under oath and say, I was not aware of it. And then one of the worst comments he made, which really defies logic in my opinion. He says, well, my son was drinking it. Now, did he know that his son went to the hospital? And that his vice president of marketing said it's in the water? And then still say under oath that he was not aware of it? And I want you to consider this for a second. Blaine Jones decided to drink that water. And he knew about the people getting sick. Compare that, ladies and gentlemen, to a drunk driver. A drunk driver gets into a car having consumed alcohol, inebriated, drunk, and takes his own life into his own hands, correct? Does that give him the right to compromise the safety of everybody else on the streets? That's what Blaine did. If Blaine wants to drink water that had feces in it, that got people sick, that caused termination, that's on him. But none of these plaintiffs knew about it. And they kept drinking their water because it's the healthiest water that can be marketed. Safe for you and your children. Your health depended on it. That's what that bottle says. And that's what they did. So when you use some argument in opening or closing, Blaine drank the water. Well, if Blaine wants to play Russian roulette with his own gun and his own brain, that's him. You don't do that to your customers. You don't do that to the public. Real water has to be sent a message. Next slide, Shane. Open up. We know the slide. So finally, ladies and gentlemen, Real Water did not have the right to gamble with the lives of these 13 plaintiffs, its customers, and the public. Every time they came on Monday morning, like Ms. Converse said, they were so important to them, that how many trucks got out, how much product got sent out. They were gambling with the public's health, and they knew it. They knew it from 2013 until 2020, and when the CDC, FDA, and the Southern Nevada Health District came knocking on their door, they didn't do anything to cooperate. In fact, they refused to cooperate over and over and over and over again. Ladies and gentlemen, there's an overwhelming amount of evidence in support of punitive damages. And I would ask that after you consider this and focus your attention on the evidence, that you come back striking the box in favor of punitive damages. Again, the punitive damage phase typically lasts less than an hour and a half. It's typically only one witness and his argument, and that's it. Thank you so much.
Okay, thank you, Mr. Parker. And we're going to take a quick restroom recess. We probably need to go. And anyway, you're admonished not to converse amongst yourselves or with anyone else on any subject matter connected with this trial, or to read, watch, or listen to any report or commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. And last but not least, do not formally express any opinion on any subject connected with the trial until the cause is finally submitted to.
All rise to the court is adjourned.
Thank you.
Department 16, now come back to work. Please be seated, thank you.
On the record,
All right, let's go ahead and set forth our appearances.
City Parker, plaintiff, Your Honor.
Robert Eagle, plaintiff, Your Honor.
Maggie Federico for plaintiff. Rhea Swift for plaintiff.
Brad Johnson, Tyler Watson, Mike Esposito, and Eric Freeman on behalf of the defendant.
All right, and it's my understanding you have something outside the presence, sir?
Yes, briefly, I know we want to get going here, Your Honor. We had on the issue of punitive damages, there was a stipulation regarding what was going to happen in terms of punitive damages at the bankruptcy court, and then subsequently in this particular court, there's a number of orders basically laying out that we could not state the size of the company, the fact that the company was out of business, the fact that the company had gone bankrupt, etc., because it was not going to be affecting them, and instead, because of that bankruptcy, etc., but instead it was going to be a deterrence to third parties from being acting the way of Real Water. That was what it was, deterrence. Yet the arguments that have been presented, in addition to simply pointing out plaintiffs or defense counsel and things of that nature, is punish Real Water. Punish Real Water when this aspect of the case was supposed to be for the deterrent, and the court made rulings on that and prevented us from presenting defenses in terms of, well, we don't have any money to go after. In a typical punitive damage case, we would look at our finances, and the court said, well, they're not coming after you, it's for deterrence, yet that is the arguments being made. Blaine Jones is a bad guy. Brent Jones is a liar. A lot of arguments that are inappropriate, and it needs to stop. And that's my objection. Thank you.
All right.
Judge, we're focused on conscious disregard of this defendant. That's the standard for the yes or no. Conscious disregard of this defendant, not conscious disregard of in a deterrence capacity. And so I don't think
The objection's well taken. Anyone else want to add?
He's got it.
Mr. Parker, I mean, you're looking at me.
No, you know, I want to give Mr. Eglett done, Your Honor. I think the court has heard this argument before, 4 times, so.
Well, I just have a comment, you know, punishment and deterrence are not mutually exclusive.
Nope.
Right? I mean, they're not. You know, and part of deterrence is punishing others. Right?
Yeah, but they're saying punish real water.
Yeah.
And pointing out the individuals in real water, Your Honor. That's not punishing and deterring third parties. It's directed at real water.
Well, ultimately, don't you think that whatever, I mean, maybe we won't have it in this matter, but if there is one, it would have a deterrence impact on other third parties.
That's what
And
the
that's why
case says, Your Honor.
I know. I mean, I read these cases, Mr. Parker.
Exactly.
Here's my point, though. They're not mutually exclusive. And that's all I'm trying to say.
That's right.
And at the end of the day, and this is really a fascinating issue. I don't know what the ultimate answer is going to be by our Supreme Court on how to deal with a punitive damage claim when the defendant files bankruptcy. I don't know what they're going to do. But I know this, and I do agree with this. Normally, the finances come in, but under the circumstances of this case, they would not come in because of the bankruptcy.
That's right.
I get it. You know, it's a novel issue. It's very unique. But anyway, what we'll do, we'll continue on.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir.
Work your magic.
What do we do when we're done, Mr. Eglett? Mr. Johnson, what do we do when we're done? We haven't talked about that. What do we do with the jury?
See if they want to deliberate for a while.
That's fine with me, Your Honor. They seem
I
like
just
they're
wanted
ready to get
okay,
going.
we're all on the same page. That's fine. I just wanted to make sure. That's all.
And they can
That's normally what we want to know.
You're out tomorrow, maybe.
What's that?
They can come back and deliberate early tomorrow too, right? You don't have to wait for court.
Oh. I don't know, how does that work, Your Honor, in terms of the jury, if they can't finish up tonight, they're deliberating tomorrow, will they just come by at a certain time?
Yeah, they'll be here at 9 o'clock.
All right.
And let's continue on.
That's good.
All rise for the jury.
Does he go longer or shorter than 5 p.m.? It's going to be long. Why do you care about that much? Do you already say? A lot of things I think you're going to say.
Please be seated. Thank you.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, sir.
All right, Mr. Eglett, you have the floor, sir.
Thank you, Your Honor.
Good afternoon, everyone. I got a little exciting earlier this afternoon, huh? Anyway, fortunately for you, I am the last one you will hear from before you finally get to go back and deliberate for this case. And I promise I will try to be brief. It's kind of hard for lawyers, I know, but I will try, I promise. And I want to start by thanking all of you for your service as jurors. So as jurors, you play a critical role in our democracy, and a lot of people don't understand this. And for the most part, aside from voting, it is the only chance that most people have to play a significant role in our democracy here. And that's because jurors, through their verdicts, can effectuate change for the better in our country. And they can effectuate positive change almost instantly with one verdict. And that would take Congress decades to accomplish, if at all, because of the power and money that corporate America has to stall or outright stop
such legislation from ever passing. And there are countless jury verdicts that have done just that, because they were significant enough to get corporate attention and make them realize that continuing with business as usual will not be cost effective for them in future jury verdicts that are surely to come. So they changed their business as usual model and make America a little more safe again. And it is juries that make that happen. A goal that Mr. Kemp, Mr. Parker, and myself have been pursuing for our entire careers, to make America safe again from corporate greed and indifference to the safety of the consumers who buy their products. And so it's our hope that you will help us to do that with your verdict here. So thank you. So Mr. Johnson's closing argument regarding the damages in this case reminded me of the definition of a cynic. You see, a cynic is someone who knows the price of everything and the value of nothing. There's a difference between price and value, ladies and gentlemen. Price applies to something that we can purchase or sell. It represents the amount of money that is obtained and paid in a transaction. But value is the worth of something to the individual. And that distinction is particularly significant in a case like this. There is a big difference, ladies and gentlemen, between price and value. And when we face the question, such as presented in this case, we are controlled by the principles of value, not price. This is because Lisa King, Andrea Bourdonnais, and the other 11 real water victims here did not voluntarily subject themselves to be inflicted with myasthenia gravis, autoimmune hepatitis, liver failure, and permanent liver damage, resulting in pain and suffering, fear and anguish, extreme emotional distress, and for most, fear of the unknown. But for Lisa, fear of the unknown and the known that will surely happen to her. These people did not voluntarily trade their physical health for real water's money. Indeed, no one could seriously argue that anyone would voluntarily do that. This tragedy was thrust upon them by Real Water's unreasonably dangerous, defective water laced with hydrogen, a deadly rocket fuel that can kill and cause liver failure, resulting in liver transplants. There is no price for physical pain and suffering, anguish, mental suffering, and the loss of enjoyment of life. You cannot purchase them off the shelves at a grocery store. You cannot buy them by the gallon at a service station. When you walk, when we talk about loss of a loved one, for example, such as the death of a son or a wife, the initial question is always, whose son? Whose wife? Yours or mine? And that's because we naturally feel that no amount of money could possibly replace our own son or our own spouse. The same concept applies here. Let me give you an example of what I'm talking about. Many of us know of shut-ins. They are usually elderly people who, because of their physical limitations, are not as active as they once were, and spend virtually all of their days
in their homes, apartments, rooms, or nursing homes. Each of you may have a mother, an aunt, a grandmother who fits this picture. And you have been, if you've been around these people very much, you know that their TVs, their television sets, are the center of their daily activities. They use their TVs to keep in touch with the world, stay familiar with what's going on, to be entertained, to remind them of happier times in the past, and bring them laughter and enjoyment. It's their touch with, it is their touch with reality of the outside world. And it is, though they have someone with them around the clock, so they are not alone. Reruns of Oprah Winfrey, Andy Griffith, and the I Love Lucy show. I know I'm dating myself now, right? And a countless line of people visit with them every day. The price of their TV may be $400 to $500. But if you were to go to these elderly people, any one of them, and say to them, I will give you 10 times what you paid for that TV, even though it is used, even though you have used it for a few years, I will take it off your hands and I will give you 10 times what you paid for it. But the only thing that I demand is that you not buy another TV. You can never own a TV or an iPad or a computer that you can stream TV on again. And every one of those shut-ins, every single one of them, in every case, would not accept that offer. They would not sell. And that is because the value to them of that TV is much greater than the money that you are offering them. Mr. Johnson's great news claims in this case, even at the end here, that there was no follow-up treatment for all the plaintiffs. Not true. Lisa has had 21 IVIG treatments and continues to have countless doctor's appointments. Second, he said there's no monitoring for all the plaintiffs. Not true, or there hasn't been. Lisa continues to have quarterly blood tests and quarterly to biannually medical visits at Loma Linda for her autoimmune disease, autoimmune hepatitis. He says no psychiatric treatment. Lisa explained this and said she is ready to start treatment. And Lisa was diagnosed with PTSD by her treating physician in addition to Dr. Sands. And Real Water has stipulated she was diagnosed with and currently suffering from PTSD. Right here in jury instruction number 12 tells you that. The parties hereby agree that plaintiff Lisa King has been diagnosed with and currently suffers from PTSD. Mr. Johnson also claimed for all plaintiffs that no medications or prescription, there's been no medications or prescriptions provided since they were released. Lisa has never stopped taking Urso for her autoimmune hepatitis and takes multiple different prescriptions for her MG, which she and Dr. Mahajan both confirmed in their testimony.
Did Dr. Gersh give you any medication to treat your autoimmune hepatitis?
He did. He gave me a medication called Ursat.
Short version is Urso?
Yeah.
Okay. Now, do you still take Urso to manage it?
I do.
What treatment did you recommend for Lisa at this time?
Initially, I recommended a medication called presiding. It's a medicine that allows the communication between those muscle junctions to work more effectively.
Did Dr. Mahajan prescribe you any medicine to treat your myasthenia gravis at that time?
Yes, they gave me a medication called presiding. It's also known as Mestinon.
And do you still take periodicity?
I take it as needed, and I have had to take it, most recently I was in the hospital, so I've been taking it 3 times a day.
Mr. Johnson's tactics continue in his closing argument. And his tactics have always been, this has always been his tactics. When the law is against you, then argue the facts. When the facts are against you, then argue the law. And when the law and the facts are against you, try to confuse the jury. Mr. Johnson went over the top by trying to confuse you in his closing argument. Dr. Hutt never said they should test the water before the manufacturing process that produced hydrazine in the real water. That would just test Clark County's municipal water. He tried to confuse you about degrading. The degrading was of the hydrazine over time. So if a test is done months after the real water was bottled, it will have a lower content of hydrazine in it because the hydrazine degrades over time than it did when it was first, so it has less content of hydrazine in it when it was first bottled. Because the hydrazine degrades, and that's why. That's the degrading process. Mr. Johnson tried to confuse you by claiming it was the degrading of the real water after the manufacturing process that caused the hydrazine in the real water. And thus testing at what he called Jump Street wouldn't have shown any hydrazine in the water. That is utter nonsense. That is not what the testimony and the evidence and the facts have shown in this case. And it is a clear attempt to confuse you. And that's what lawyers for corrupt corporations do when there is no defense for the corporation's corrupt conduct. That's what they do. So Mr. Johnson tells you they didn't know there was a problem with the water. This is not a company that has learned its lessons, ladies and gentlemen. We know this from the testimony of their CEO and president. And you just saw a long version of this. I'm going to show you a real short version.
We had no idea that I had no idea that our water was causing problems. My own son Blaine got very sick, and at the same time, we didn't stop drinking rural water. We didn't have any idea that it was associated with rural water whatsoever. I mean, he got sick himself, and if we would have thought it was rural water, we would have done something. At that time, we didn't because we didn't know there was any association whatsoever with rural water. So no, I did not think that there was any problem with rural water in October or November of 2020. I was completely blindsided when it happened in March.
I guess he didn't know about that their head of sales, Anthony Randolph, telling them about all the people getting sick and begging them to do a recall months and months before this. I guess he didn't know about the dozens and dozens and dozens of customer complaints they received. I guess he didn't know about the quality assurance score they received of 6.7% out of 100%. I guess he didn't know any of that, the CEO of the company. Mr. Johnson claims and tells you that Lisa is able to handle her work obligations, but he fails to mention she does them from home or from a hospital or outpatient surgery bed. Mr. Johnson claims that Lisa is able to travel still and talked about a trip to Puerto Rico and Budapest she took in 2018, but fails to clarify that that was before her MG symptoms began to debilitate her. He claims that her PTSD doesn't warrant treatments for life, but he fails to tell you she was diagnosed with PTSD by her treating physician, not Dr. Sands. He diagnosed her too, and fails to tell you that the jury instruction 6 says that you must bring to the consideration of your evidence your everyday common sense. And what would your everyday common sense tell you about having a strong, independent woman who has always been in control of her life since she was 16 years old and pregnant with her daughter, who has built an incredible family, career in healthcare, and side career commentating MMA fights on NBC, ESPN, and other networks, hosting events around the fighting community as well as charitable foundations. And now her health has been destroyed. She will eventually lose her mobility. She can't speak at events for the fighting community or charitable foundations because her speech might slur, whose condition will only get worse, and her symptoms will only get worse, and she will continue to debilitate until she is totally dependent on others. Does your common sense tell you that her mental health will improve as time goes on or get worse? Do you think she might need to talk to a professional once a week so she doesn't have to, because she won't do it, burden her family and friends with her mental health issues? Or do you think, like Mr. Johnson, that it's great news for her? I don't know if you remember this quite some time ago when Dr. Mahajan was testifying, but this is the board that he marked up for where Lisa is feeling all of her symptoms. I want you to look at this. Both her feet, both her legs all the way up and down, both her hands, both her arms all the way up and down into her shoulders and into her neck. Her abdominal area, most of that is the autoimmune hepatitis. Her neck, which closes up and could kill her if she doesn't get to a medical facility in time. Her face, her cheeks, her mouth, for her speech problems, her eyes for blurry vision, and her head. It is top to bottom and everything in between. The symptoms that she has, and Dr. Mahajan told you she continues to have. Yes, not all of them at once, but she has them. Dr. Mahajan marked on this exhibit all the places on Lisa's body where she has had symptoms and will continue to have symptoms. Does anyone here think this is great news? So if Blaine Jones' pain and suffering lasted a week at most, which is what happened, of the hell and back he says he went through before he felt better, and Lisa's King's pain and suffering, mental anguish, and loss of the pleasures Lisa enjoyed in her life, which she will suffer for life, and which will only get worse for her if Lisa's pain and suffering, mental anguish, and loss of enjoyment of life for the past 7 years and over the next 34.3 years over her life, or so a total of 41.3 years, that she will actually be in hell and will not come out. If her past and future pain, suffering, mental anguish, loss of enjoyment of life is not worth at least 15 times the 10 million that Blaine Jones said he wouldn't even accept to go through again, then I don't know what else to say. $150 million is a bargain here, ladies and gentlemen, for the suffering Lisa has endured and will be forced to endure for the remainder of her life. Blaine Jones testified 1 week of his pain and suffering is worth more than $10 million. Lisa King has had 364 weeks of past pain and suffering, and she will have 1,784 weeks of future pain and suffering. If you add those up, that's 2,148 weeks total. Using Blaine Jones' baseline testimony of $10 million per week, the value of Lisa's past and future pain and suffering for 2,148 weeks is $21,480,000,000. So our suggestion of $150 million for Lisa's past and future pain and suffering is a bargain. So what I'm going to do now, ladies and gentlemen, is not say anything for a few minutes and let Lisa's best friend Dawn, her son Porter, and her partner Brent, and Lisa do the talking for Lisa.
How would you describe Lisa in one word?
Lisa's a fighter.
Why do you choose that word for Lisa?
Well, think about everything that she's been through in her life. Back to the beginning of Lisa, back to a teenager who found out she's pregnant, is a minority living in a small town, and all the adversity that she had to face to push forward in her life and decide that she's keeping her baby, she's raising it, she's not just going to become a victim to any circumstance, that she chose these things, and that she's going to train herself, and she's going to take the jobs, and she's going to make it, and that's what she did. She was never a victim to anything that happened in her life. We started thinking, we got to try to plan, we got to try to come up with a plan. Like, EMTs don't always show up in time here. So is it going to be better if her airways start to shut down? Is it going to be better to call 911? Or how far is the hospital? What hospital are we going to take her to? We started putting it in the maps, timing things out. We had to get Porter involved. We're trying to make sure he knows, like, well, her airway checks, what's she going to look like? How long may you have before her heart might stop? You know, are you gonna call 911? Are you gonna put her in the car? We're trying to make plans. And I looked at her eyes with her crying that way, and I just saw this look in her face. And there was so much fear in her eyes that I've never seen that type of fear before from her. And it shook me. And I'll never forget that day.
I'd say the scariest symptom was that she felt like her muscles in her airway were closing, and that she had difficulty breathing. And there was many nights where I would sleep outside her room. There was a living room that's very close by. I'd sleep on the couch, and I would try to monitor during the night, make sure that she essentially didn't stop breathing in her sleep.
When her speech started to slur, what areas of her life did that affect?
I mean, it affected really everything, you know. She talks for a living, so I mean, whether it's ring announcing, commentating, you know, TV stuff, her actual day job, which is marketing and giving presentations to, you know, hospital executives and such. I mean, that's her whole life, you know.
Has your mom expressed any fear about her illnesses or the future to you?
Not directly. She's not the sort of person to try and burden others with the way that she feels, but through her actions, you can see, I mean, she has essentially like a book of death. In case she passes away, it's for, you know, me, Courtney, and Brent, that we know what to do in the event that she's not here anymore. And that came from when she got sick.
So now I just became very sensitive that her gesture to her neck probably meant, like, we're going to the ER, you know. So that was quite revealing, because at first I was just like, oh, she's just having a breathing problem. But then as I would see it panic her, I would see that she's like almost thinking like, if I don't get somewhere, I'm going to die.
What about when her speech began to slur? How did she deal with that?
That was like, I felt, right, when that started happening, I felt that she felt that it was like the beginning of the end for her. Because that's what she does. She's been a proud speaker, motivator, you know, commentating at the games, at the fights, being able to talk to her staff, all these meetings and seminars that she does. She is a talker, and she's very proud of it, and she's excellent at it. And then the other part was when she would get hired for these outside gigs to go to the fights, to commentate, to be the person in the ring, you know, she would have to give those gigs up. And if you're a gig worker, like I am, she was doing the side gigs, you know when you give the gig up, you don't get it back. You never get it back. No matter how much your client loves you, you know you're not going to get it back, because you always lose it. I know that. She knows that, you know, and she loved doing that. She loved being at those fights. I watched her. She would invite me to those fights, and she was amazing. And the fact that now she has to pan that out to other people and never get it back, yeah, that was a big deal to all of us.
Does anything about her future treatment scare her?
Well, now that the future treatments are going to be every month, 2 days a month, and the side effects that happen every time, because I've been there on almost every dosage, the inconsistency, but that's going to have to happen every month. Yeah, that is, because it's not really 2 days, it's like at least 2 weeks. So it's not like 2 days a month and we're going to be out, and it's at least 2 weeks, because it's the unknown of, like, is she going to get a big headache this time? Are they going to blow out her vein because they're so weak? There's just so many questions, no matter what, and to be dependent upon that for the rest of her life is more devastating than I can even imagine.
And there was one point where my daughter was out of town around the time that I was going to be hospitalized, and she was doing a class for cosmetology, and you know, I knew she'd be back on Friday, so I called her and I said, you know, when do you come back? And she's like, Friday. And she's like, how are you doing? And I'm like, you know, not great. And I said, when am I going to see you? And she goes, probably next week I'll come see you. And I said, well, you know, I want to come see me sooner than this. And I'm going to do my best not to cry. But she was just like, why? And I was like, I didn't want to freak her out and say, I don't know how this is going to play out, but I honestly didn't know if I was going to make it. So I just said, you know, you need to come see me sooner rather than later. You know, my body's doing weird things, and I want to see you. So, and my son was there, and I'm trying not to freak him out. Obviously, his father had died several years before, and, you know, I'm trying to keep a brave face. But yes, I wholeheartedly thought I wasn't going to make it. I even called my attorney who had done a will for me, and I was like, is everything okay in my will? Do I need to update anything? You know, I just want to make sure everything's good. You know, I'm now at this time trying to prepare for, in the event my body doesn't make it.
How did you feel, Lisa, when you realized your myasthenia gravis and your autoimmune hepatitis was caused by you drinking milk?
To say that I was angry would be an understatement. I wholeheartedly felt betrayed, because I worked for this MMA organization owned by Real Water. They physically provided me real water. And I just felt really lied to. You know, it was deemed the healthiest water out there.
Well, they deemed it, right?
They deemed it the healthiest water out there. And instead, I've got illnesses for the rest of my life. You know, I feel like I've given up a lot of things as a result of my illnesses. I've given up my ability to do all of the commentating that I like to do as routinely as I like to do it. I've given up my ability to do all the fundraiser activities the way that I want to do them. I've given up my ability to travel around doing motivational speeches, just due to the uncertainty of how I'm feeling. I spent my whole adult life training to be an elite athlete. Now, don't get me wrong, I wasn't fighting, but I was still training people. I was teaching at gyms. I was doing a lot of things that I like to do. I'm not able to do that. I was always in the best shape of my life, and sometimes I can't work out for months on end. So I have given up a lot due to the ailments I now have as a result of Real Water. So for me to give in really kind of just feels like defeat. And so I will do what I can to push through, to continue having my job, and just not give it up. At least as long as I can until, you know, I can't continue or my work can't accommodate me the way that they've been doing. You know, I've given up enough to Real Water, and at this point, I don't want to give up my career as well.
How do you feel when you think about the future? How do you feel, Lisa?
It's scary. It's very scary. It's, you know, I think my biggest fear is the fear of the unknown. And I absolutely have loved my independence, and I never want to be a burden to my family, and kind of the trajectory that I'm going down, it kind of feels like that's just something I just might have to deal with. Again, I don't like that I have to pre-plan for every aspect of my life in case what if. That's not fun. And so again, I'm angry. And I guess I'm just doing the best that I can with what I have.
This case was brought, ladies and gentlemen, because Real Water would not listen. Real Water would not listen when they learned from the man who sold them the manufacturing process, and that he didn't even really know what the manufacturing process actually put in the water. Real Water did not listen to dozens and dozens and dozens of customer complaints of getting sick from drinking Real Water, including one customer having liver failure and recovering from his liver failure by stopping drinking Real Water. Real Water would not listen to multiple customers' complaints that the water smelled like gasoline. Real Water would not listen when they received the results of the audit of one of their manufacturing plants and learned that they had virtually zero quality assurance, scoring 6.7 out of 100% on quality assurance. Real Water would not listen to the head of sales who begged them to do a recall because so many customers were getting sick, including the vice president of Real Water. Finally, Real Water would not listen after we provided them extensive and uncontroverted evidence of the harms and losses Real Water has inflicted on Lisa King, Andrea Bordenave, and the other 11 Real Water victims here, including the extensive trauma, anxiety, extreme emotional distress, and fear they all have to carry and will for the remainder of their lives because of the damage that was caused to their lives by the hydrazine Real Water manufactured into their bottled water. So perhaps, ladies and gentlemen, just perhaps, they will listen to you when you return your verdict. Thank you.
All right. Okay, and I guess that completes the arguments, is that correct? Okay.
So. Can you give me that?
You want this?
Yes.
Yes, ma'am.
Thank you.
All right. Ready to swear in?
Yes, I'll swear in the bailiff first. You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God?
I will.
Thank you. You do solemnly swear that you will keep these alternate jurors in some private and convenient place, that you will not permit any person to speak to them unless it is by order of this court, so help you God?
I will.
Thank you.
All right, ladies and gentlemen, as far as the trial itself is concerned, it's completed. Right now is the time set for deliberation. The marshal will escort you to the jury deliberation room. He will be your contact along with the matron that's with him that's been sworn in. Now, one of the things I want you to make sure you understand, I know the time. It's 4:35, a little bit after 4:35, and we will begin our deliberations once you get into the jury deliberation room. But it's up to you to decide what you want to do. If you understand what I mean. If you want to deliberate tonight, that's your decision. If you want to talk and you want to come back in the morning, that's your decision. I guess I can kind of bottom line it for you. They did get the trial finished within the time period promised, right? They did. Because what is tomorrow's date, the 21st? Right? And then, isn't that the date we set on the jury questionnaire? Yes. Okay, so you'll be in the possession, custody, and control of the marshal.
Thank you, Your Honor. All rise to the jury. Take everything with you, all your notes and everything. This is your time to shine, guys. Okay, read your book.
Yeah, I didn't win that one.
We go on the record, man. All right, you may be seated. Okay, ladies and gentlemen, before we leave, I do have to give you the recess admonishment, and I guess this is slightly different in this respect. You're in deliberations right now, and just remember, as far as deliberations are concerned, you can't go to any independent sources, you can't conduct your own research, and you're limited to the jury instructions and the evidence that's been given to you. Does everybody understand that? And so it's my understanding, too, you want to come back tomorrow morning at 8:30? Okay, and the marshal will be here, and he'll make sure you're accommodated, he'll get you set up so you can start your deliberations or continue deliberations tomorrow morning. Everybody understand that? Okay. Well, I want you to have a safe trip home. We look forward to seeing you tomorrow morning, and I just want to thank you once again for your service. All right.
Did you read that, Your Honor?
This is.
You did.
I've read it in a different manner because the case has now been submitted to them.
Thank
right?
You.
Okay.
All rise to depart to the jury.
Have a safe trip home.
Yeah. And I told you guys, I thought she was really ill. I would rather have her.
Jury's clear.
Thank you.
Yeah,
I'll see that.
Thanks, everyone. Well, we need to know she's even ready to go into the stuff. And then you said something about, honey, thinking she's scoffed. I told her, I said, she just snickered or scoffed at her. You couldn't tell.
Yeah, Judge, there's one witness for the punitive phase. It's Mark Rich, And there's a little bit of a disagreement over some of his deposition testimony to be played. So I think it would be prudent if we pick some time tomorrow to go over it, if you're available.
Oh, I'll be here. What do you think, 9:30?
9:30 is
9:30 would be great, Judge.
Yeah, that way we don't have to make it too early.
Right.
It's a Friday, right? 9:30 it'll be.
9:30 is.
Just for clarity, are plaintiffs going to provide the objections in advance? You are? Okay, great. Thank you.
I'm typing them up right now.
Thank you.
All right. Okay.
Thank you, Your Honor.
You're welcome.
Have a good night, everyone.
Yeah.